Many people believe that if you've been flashed by a speed camera, but you don't receive the NIP, the Notice of Intended Prosecution, within 14 days, that the police cannot proceed. And that isn't quite true. And that's because there are many reasons that you might not receive it within the first 14 days. It might be a delay in the post. It may be because the vehicle was registered to a different address. It may be a hire vehicle, a lease vehicle, or the address might be just plain wrong. However, the idea comes from a technical loophole of sorts. That being, if the NIP is dated more than 14 days after the alleged offence, then they cannot proceed. And as a side note, another technicality is that if it's not signed on behalf of the police, remember, signed could just be a typed name. It doesn't have to be physically signed or even with a wet ink signature. But either way, if it hasn't been signed, then again, it's not valid. One of the main reasons you shouldn't fall for these kind of myths, however, is that the NIP is going to be sent to the registered keeper of the vehicle, which, if that isn't you or your address, but you are the one driving, then it certainly will be valid against you as the driver. However, having been sent to the registered keeper of the vehicle, they have 28 days to identify the driver and to sign a declaration that that information is correct, or at least that they have expended reasonable and all due diligence to find out who the driver was at the time of the alleged offence. Another myth following on from this NIP is that if you don't receive the court papers within 6 months, then again that they can't proceed. And again, this is not true. Failure to receive these papers within the first 6 months is not a defence to the alleged offence. However, the police do have to commence proceedings within the first 6 months. That is known as laying an information before the magistrates to commence a prosecution against you, and that certainly does need to be done within 6 months of the date of the alleged offence. Even one day over and the prosecution will be out of time and will be thrown out of court. Another myth, as a side note, is that many people believe that the police have to give you all of the evidence they have against you, and that you can fight against it to tell them that they have no evidence because they haven't provided you with the evidence. And again, that isn't true. Giving you a fixed penalty at the scene, for example, is just the police's way of giving you a simple way of dealing with this without going to court, so long as you deal with it within 28 days. But if you don't accept the fixed penalty, the police are not under an obligation to provide you with all the evidence until they've commenced proceedings in court. However, if you are stopped by the police and they are giving you notice of intended prosecution, the police must be in uniform and advise you of the general nature of the offence at that very moment. Although there's no need for them to give you a formal written notice if they intend to prosecute you, so long as you are warned at the scene and at the time of the offence. However, and as a side note, it is another myth that some people believe that if a police officer is not wearing their hat, then they're not in uniform. That is obviously not the case, and police who are clearly in uniform, with or without the hat, are still in uniform. So as always, please make sure you take formal legal advice before relying on any of these kind of myths and alleged loopholes that you might find on the internet, because if you end up in court, it could be far more serious than the fixed penalty was in the first place. So please give the video a like, subscribe, that really helps my channel grow, and I'll see you next time.